Please be seated. The court is now in session. The floor will be given to Defense Counsel for Mr. Nunjia to continue questioning this witness. However, before we proceed with the defense question, the chamber would like to ask Casas Bao, please stand up. Counsel, the articles that you referred to, the one that was written by Steve Hedder before we broke, could you tell the court whether that document is in the case file or whether it is in any list of the proposed documents of any parties, and what is the title of that document?
Thank you, Mr. President. The Steve Hedder article is on the shared material drive. I could have provided you with the ERN numbers, but one of your legal officers came earlier and I seem to now have misplaced it after I discussed the document with her. But the document is called, if I speak from my mind, Reassessing the Role of the Senior Leaders of Democratic Cambodia. And perhaps I can, I would be able to, after this court session, to provide you with the exact ERNs. And we have submitted it as part of an earlier application, so it should also have an document number as part of that application, but I again would not be able to provide you with that at this point in time. Again, we simply referenced it because it's in the public domain and it's relevant to the current proceeding, so we don't want to rely on it in any way, shape or form apart from impeaching this witness. I hope this information suffices.
The President, Mr. Justice Bao, you haven't answered my question yet. Is the document on the case file of case 002? Or is it in any list of documents proposed by any parties? This is my question, counsel. You should have answered my question straightforward.
I was under the impression that I was answering your question straightforward, Your Honor. This document is on the shared material drive where it can be found. We have relied upon it in the past, and as far as I know, well, let me phrase it this way. I do not know if it's on any document list submitted by the other parties.
President, thank you. Now, International Co-Prosecutor, you may proceed.
Thank you, Mr. President. I can't tell you for sure because counsel hasn't provided us with exact information, but there is at least excerpts of what I think is this article, an article by Steve Hedder entitled Reassessing the Role of Senior Leaders and Local Officers or Local Officials in Democratic Kampuchea Crimes, that was included on our annex and is in the case file as D366/7.1.828. What I can't tell for sure is whether the entire article is included in the case file or just portions, but I can confirm that portions at least of this article are on the case file and were on our list.
President, thank you for information from the co-prosecutor, Counsel Pam. The Chamber reminds you once again, as the Chamber has been reminding your defense team several times, that you should follow the instructions regarding the request to refer to documents to be used to confront with witnesses or civil parties. Counsel should first indicate whether the document has been put before the Chamber or whether the document can be found in the list of the proposed document of any party. Secondly, Counsel should identify the document number, the title of the document, and year and numbers in 2 or 3 languages. Other parties have been following this instruction properly, and we have been doing this for more than 70 days ago. So we should not have any problem of this kind, and you are reminded to follow such instructions. You may now proceed with your questions to this witness, Counsel.
Mr. President, just asking for a clarification. Am I to understand that we are not allowed to quote from scholarly articles that can be found in the public domain without wanting to rely on them for any evidentiary purposes? This is, again, a scholarly article by a well-respected scholar that has worked for the OCIJ and for the OCP. I can access this document in any library that has this particular book, and I'm not sure why we should not be allowed to at least refer to this document in statements. I didn't show the document to the witness. I'm just conveying information that is out there in the public domain and that is relevant to this witness. If we're not even allowed to do that, it becomes a somewhat surreal exercise, and I would like some guidance on this issue. And I remind you that, again, we have already referenced this document during the questioning of an earlier witness, and that proved to be no problem whatsoever. So that practice that you referenced of 70 days of following this procedure is at least not very consistent. So some guidance on this issue would be appreciated, and I do think that if we are not even allowed to quote scholarly works that are available in the public domain, there's not much role left for any defense team here. I would like some guidance.
Yes, International Co-Prosecutor, you may proceed.
Yes, Mr. President, I'd like to quickly respond to that. I find that comment inappropriate given that he was allowed to use this. The point here is one of notice. It's of notifying the parties in advance of the documents that are intended to be used. Counsel should have informed the parties of the identity of the document he was using, so we all could review that ahead of time. Furthermore, while I have no problem with counsel making references to this analysis, I failed to see why it was necessary in questioning this witness. This witness is not a scholar on this subject. It would have been simply sufficient for him to ask the question, who had authority to order arrests and executions, district level, sector level, or the center? So I failed to see how counsel has in any way been obstructed from conducting examination. This is simply a matter of him providing notice to the parties of the documents he intends to use.
Mr. President, if I may briefly respond, if that's the only issue as far as the prosecution is concerned, we agree. If we would be more than willing to provide adequate notice of documents such as the one I used before, if we are actually allowed to use them to ask this witness questions relating to that document. So I think there's no disagreement between the prosecution and us. But I understood your ruling to mean something else, and that is that in the future we will not be allowed to use documents such as this one. And if that's the case, I think my request for guidance stands. So it's in your hands.
The President, I now hand over to Judge Loven to address the matter raised by Defense Counsel for Mr. Nguyen.
Thank you, President. First and foremost, as an introductory comment, the Chamber has observed that it is most regretful to spend so much time to be reminding parties of the rules that apply to all present. That one would want to use documents during the proceedings would entail that the document is admitted into the proceedings. The Chamber has come to several decisions on this matter, and they apply to all, including the Nunchia defense team. I believe that it is timely for you to realize that you are obliged to abide by the rules that have been made explicit by the Chamber. Now, with respect to documents that fall within the public realm, written by a university researcher or scholar may contain interesting information, but that does not make such a document exempt from the rules. All parties would want to be informed in advance of documents that serve as a basis for questioning of a witness. This is a minimum. It is up to the Chamber to decide whether or not such a document is new, if a document should or should not be admitted into the proceedings. The Chamber is to decide whether the document is relevant or if it should help in ascertaining the truth. It would be most appreciated for you to deploy a minimum amount of effort and execute this task. We are using much valuable time to be discussing such matters. I hope that this makes issues clear for all.
President. Thank you, Judge Levin. And I would like to add that the documents that the parties have placed in the interface cannot be used interchangeably to fulfill Internal Rule 87.4. Rule 87.4 is the rule that governs the use of documents in the trial chamber. Regarding the information to be provided to relevant parties in advance is something that we should do in order to facilitate the procedure, that is to expedite the proceeding. So I hope that parties are not mistaken with this. Parties cannot understand it that parties have fulfilled the requirements when they place the documents in the interface. Instead, parties need to follow what has been prescribed by Internal Rule 87.4 together with Internal Rule 87.3 regarding evidence. Counsel may continue his questioning now.
Thank you, Mr. President, and I agree we are spending too much time on these issues, and I will not revisit our arguments. I will just state for the record that if we are in possession of exculpatory documents, it is our duty as defense counsel to try to use that to impeach a witness, and we have no other choice. This is our duty as defense counsel, and I'll leave it at that for this moment, because I think indeed continuing this hearing or this questioning of the witness is more important at this stage. So with your permission, Mr. President, I would like to continue and ask Mr. Sausaroon a few more questions. I think I should be able to finish this before the end of today's hearing. And first of all, I would like to revisit one meeting that we discussed before the break, because as I indicated at the time, I thought there might be some confusion as to which meeting we speak about. So, Mr. Sausaroon, I want to ask you a question about a meeting you had in Phnom Penh, and you have stated before the co-investigating judges in document E3/367, you have stated the following, and I quote, "About 2 or 3 months after the death of Lang and Kampun, I received a telegram from Pol Pot calling the cadres to a meeting. In its contents, 6 cadres, including Ta Vieng, Ta Lork, Ta Kim, Ta Lan, Ta Sophia, and myself were called to go to a meeting in Phnom Penh. The one who received and decoded the telegram for me was San, who died after 1979. Just to be absolutely sure, do you remember that meeting in Phnom Penh, Mr. Sausaroon? So the meeting that took place 2 to 3 months after Lang and Kampun were killed.
But
I maintain what I told the investigating judges and the co-prosecutors. I have said that clearly.
Thank you. When you were asked about this meeting by the co-prosecutors on day 71, which is last week, on page 52 of the English transcript and page 43 of the Khmer transcript, you stated the following. The prosecution asked you, and when you got to Phnom Penh, who did you meet with there? Your answer was, we met with Pol Pot. The prosecution then asked you, do you recall meeting with other leaders in addition to Pol Pot? And your answer was, I didn't meet with any other leaders. Mr. Sao Sarun, do you today confirm the truthfulness of this statement?
President, witness, please wait for the decision by the chamber on the prosecutor's objection. International Court Prosecutor, you may proceed.
Thank you, Mr. President. Our objection here is that counsel is, as he did before, somewhat misstating the evidence here as he is leaving out from what he has read the subsequent part of the transcript where the witness's where the witness's recollection was refreshed. By doing that, I think he is misleading and misstating the prior testimony, but the record will reflect that he has left out the relevant correction of the witness's testimony later on.
Mr. President, if I may respond, the prosecution is is correct that I leave out the later parts where the memory of the witness has been refreshed, but I don't think that's inappropriate. To the contrary, I think that's the essence of what we have to deal with today. We are trying to establish what the witness actually remembers, what the witness remembers today, what the witness remembered last week, and what the witness remembered 3 years ago or 4 years ago when these original statements were made. So it is particularly interesting to hear what the witness has to say in response to this question, simply because we cannot assume that his statements before the investigating judges were the correct ones. We need to test, we need to verify how he found these answers, how he came to these memories. And I think that is particularly important with this witness, because this witness has demonstrated time and again that he does not remember certain things. He has made absolutely contradictory statements in his testimony over the last week that may be due to memory loss, that may be due to other reasons we don't know, but it is important to establish it for the record. What prosecution did last week was the same methods. Prosecution asked time and again to have him simply confirm the truthfulness of earlier statements before the co-investigating judges. I am asking this witness to confirm the truthfulness of a statement he made last week under oath before your trial chamber. It's in the record. He states, I quote, I did not meet with any other leaders. I did not make that up. It's in the record. So, again, I would suggest that this question be allowed.
The President, you're not supposed to make any further reply. The President, a witness does not have to answer the question last asked by Defense Counsel for Mr. Nunchie because it was repetitive.
I'm not sure how it was repetitive. I remember the OCP asking about 17 times over the past few weeks whether the statements he made before the co-investigating judges were truthful, even though he had stated at the beginning of his testimony that they were.
President, you are supposed to continue with another question. You are not allowed to use the time for any commentary. Otherwise, the time is wasted. If you do not have any further questions, please inform the chamber as such, so that the chamber can hand the floor to other party.
Thank you, Mr. President. I will inform the chamber as soon as I don't have any further questions. I do have further questions, and they relate to some telegrams that were sent by you, Mr. Sausaroon. Or, I apologize. I will ask you certain questions about telegrams that have been discussed with you by the OCP. And the first telegram I would like to discuss with you is document number D201-5.3. English ERN is 00361189, and Khmer ERN is 000209993. And with the permission of the President, I would like to show this document on the screen, and it's called Telegram 46.
President, you may proceed.
It is a telegram that has been discussed before, and it's addressed to two respected M870, and it relates to the incident with a boat that caught fire. Do you remember the telegram that we are speaking about, Mr. Sausaroon?
Response. Yes, I already indicated before the co-investigating judges, and I think that's all.
In this telegram is written, and I quote, "The measures of the sector: 1. Arrest the 2 men, and 2. Arrest contemptible Lian. According to the examination, there had been the assignment from Lian." And then it follows below that: "Carry out the arrest of these men today, the 9th. If I read this telegram, Mr. Saroon, it seems that the sector itself had already decided to arrest the 2 men without awaiting orders from the center. Is that a correct reading of the facts?
Response: no, it isn't. I didn't say anything like that.
Thank you. I look at the clock, and I will move on to the next telegram, which is telegram 54, that I would like to show on the screen with your permission, Mr. President. It's English ERN 00296220, Khmer ERN 0012027. this telegram, Mr. Saroon, relates to Comrade Sot. We have discussed, or the prosecution has discussed this telegram with you, and the telegram reads, "The issue of the situation inside the party. Comrade Sot, chairman of the repair factory, has committed immoral acts with a woman. Now the arrests have been made. Both the man and the woman have been arrested." Mr. Saroon, if I read this telegram, it suggests that the lower level had the authority to arrest persons for minor infractions. Is that correct?
Response: no, it isn't. With regard to the person by the name of Sot, I already made it clear before the before the co-prosecutors yesterday.
I am almost finished with my part of your questioning, Mr. Saroon, but the prosecution last week asked you whether the DK leaders had discussed or allowed the rebuilding of the destroyed pagodas in Mandalkiri. My question to you is, Mr. Saroon, to your knowledge, has the American government ever offered to reconstruct or rebuild those pagodas that were destroyed by their bombardments?
Response: I think I stated about this already to the co-prosecutors.
I have no further questions, Mr. President. Maybe my colleague, Mr. Sonaroon, has any follow-up questions? No, so the new Chia defense team is ready with its questioning, but it does have a request related to this witness. So is this a good moment to formulate that request? And it's really a short request that would be appropriate to be made in this hearing because it relates directly to the memory and the sources of knowledge of Mr. Saroon and the possible fallibility of his memory. It would be a 2-minute submission.
The President, you're not allowed to do that. The chamber has already reminded you time and again on this.
Mr. President, please correct me if I'm wrong, but my understanding was that if it relates to the questioning of the witness, it can be done in court, and I think it's only right for the public to know our concerns on the issue of the credibility of this witness, rather than relegating this to written submission. So, considering that it's directly related to this witness, am I allowed to make that 2-minute submission?
The President, no, you are not allowed to do that. You may now be referred to internal rules, Rule 92, concerning the closing statement. So, your request falls within the ambit of Internal Rule 92 concerning the written submission. The parties may, up until the closing statement, make written submissions. Next, we would like to proceed to counsel for Mr. Kyo Sampan, if they would wish to put questions to the witness. You may now proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Yes, I have some questions for the witness, and I believe I should be able to ask all of them before the end of today's hearing. Witness, we have on record 4 telegrams signed by you. These telegrams have been read out to you during your testimony, and you did not challenge them. The first telegram is dated 1st of January 1978, and the reference is E3 248, and it is sent to Brother 870, highly esteemed and beloved. Who is the addressee of this telegram?
Response. This telegram was sent to Pol Pot as referred to 870.
Le deuxième télégramme.
The second telegram is dated 9th of April 1978. The reference is 201/5.3. It is sent, in parenthesis, to Office 870, highly respected, end of quotes. To whom is this telegram addressed?
Response. It was sent to the same person, Pol Pot.
Le troisième télégramme.
The third telegram, dated the 23rd of April 1978, reference E3/155, is addressed, open parenthesis, to the esteemed brother, end of quote. I put the same question to you. Who is the addressee of this telegram?
Response. It was sent to Pol Pot.
Et enfin, pour terminer,
and lastly, fourth and last telegram, D201/6.2, dated 24th of April 1978, addressed, open parenthesis, to the esteemed Bong, end of quotes. Who is this telegram addressed to?
Response. The same person was indeed the recipient of the telegram.
Donc, monsieur le témoin,
Witness, I take it therefore that in spite of the different forms of politeness used in these telegrams, all the 4 telegrams were addressed to Pol Pot. Isn't that the case?
Response, yes.
Vous avez
You said on several occasions over the past few days that when you were secretary of the regions in Sector 105, you addressed your telegrams to Pol Pot. My question to you is, who asked you to act in that manner?
Response, the order was rendered from him and I had to report to him.
Pouvez-vous préciser de qui vous parlez?
Can you be more specific as to the person you are talking of?
Response, as indicated, I reported to Pol Pot, the only person to whom I reported.
Et c'est lui qui vous l'a...
And he is indeed the person who asked you to do so. Isn't that correct?
Response, yes. That was part of the order and I had to do according to what I was instructed. I had to report on a daily basis.
Et Pol...
And did Pol Pot explain to you why that decision was taken?
Response, I don't know anything about the decision. What kind of decision you're referring to?
Est-ce que Pol Pot vous avait...
Did Pol Pot explain to you why it was desirable that you address the telegrams to him and not to anyone else?
Response, he was the head and I had to report to him on whatever situation. Even there was nothing to report on, I had to do that on a regular basis.
Je voudrais vous lire, monsieur...
Witness, I would now like to read out to you an extract of the statement you gave to the OCIJ investigators. That statement was given on the 17th of December 2008, and it has been cited on several occasions during your testimony under reference number E3/367. And I would like to read out to you the audio transcript of that testimony, that statement. It is a cassette recording of the discussion you had with OCIJ investigators. I requested this transcript a few days ago, and the chamber had it done by its services. The reference is D125 E3/367. It's E3/367. I'll read a passage on page 5 of your statement of the 17th of December 2008. Question by the investigator. Did you happen to receive telegrams from Kyo Sampan? And your answer was as follows. I beg your pardon? Question by the investigator. Did you happen to receive telegrams from Kyo Sampan or Ieng Sari regarding economic affairs? Did you receive telegrams from Kyo Sampan? Answer by you. No, never. Question. You did not receive any? Answer, no. But I only saw him only when I went to Phnom Penh and when I had to discuss economic affairs with him. Question. Where did you meet him? You never talked to me about that. And when did you meet him? Answer. At the time of the meeting. Question. During an assembly? And you answered as follows. Yes, that was at the end of the assembly. Question. But you told me that most of the time it was Nuon Chia who spoke during assemblies and never Kyo Sampan. Answer. No, during assemblies or the opening of training sessions, Kyo Sampan never spoke. Question. So you spoke to him outside of the assembly? Answer. Yes. We discussed economic affairs. Question. Did you speak to him outside of the meeting, for instance, during meals? Answer, that's it. During meals, we had discussions. Investigator, I'll therefore note during meals. Answer from you, that is correct. Question, did you hold conversations with him outside of the meeting? Answer, yes. When I deemed it necessary to ask for something from him or to give him a list of points relating to economic affairs, I will stop quoting your statement here, witness. Tell me, do you recall on how many occasions you had informal occasions with Kyo Sampan on economic affairs? How often did that happen? Are you in a position to tell us so today?
Response. It was on one occasion only. And on that occasion, did you give Mr. Kyo Sampan a list relating to economic affairs? Response. No, I didn't. We only discussed about crops growing, and the meeting was conducted. Actually, I met him after meals.
Et à une autre occasion,
And did you give Mr. Kyo Sampan a list on any other occasion regarding economic affairs?
Ate.
Response: No, I didn't. I did not give any list to him.
Donc pour être parfaitement clair,
So, to be absolutely sure I have understood you, witness, does it mean that you were wrong when you answered the investigator's question on that 2nd of December 2009, on that 17th of December 2008?
Response: I think after having been seriously ill, I may have confused, been misunderstood something, so please forgive me for that.
non, mais vous n'avez pas à me demander pardon, monsieur le témoin.
You do not have to crave my indulgence, witness. I just want you to tell me, when you say you were ill, you are talking of the period when you were interviewed by the OCIJ investigators. Is that when you went wrong, or you are referring to what you said today?
Response: I had been sick before I gave interviews to the co-investigating judges. That's why my memory is not very good. I forget a lot these days.
D'accord. Et votre...
Very well. And your testimony today is that you did not give Mr. Kyo Sampan any list relating to economic affairs. Is that correct?
Matt.
Response: Yes, it is.
Je n'ai pas d'autres questions, monsieur le président.
I have no further questions for the witness, Mr. President.
The President. Thank you, Counsel. And we have very little time left. However, the Chamber would like to proceed to counsels for Mr. Ieng Seri to see how much time they would like to ask witness questions to this witness.
សូមក្រាបថ្វាយបង្គំ
Counsel Angodam, my sincere respects to Venerable monks, and Mr. President, Your Honors, and my fellow colleagues, and everyone in and around the courtroom. Mr. Sao Sarun, good afternoon. I am Angodam, and on the right hand side is my colleague, Mr. Michael Canavas. We are representing Mr. Ieng Seri. We do not have any questions to put to you. However, we really thank you very much for your time giving your testimonies before this chamber. The President, thank you, counsels, for Mr. Ieng Seri for indicating your position. This helps us to schedule our tomorrow session. Mr. Sao Sarun, the hearing of your testimony concerning case file 002 has come to an end. The Chamber would like to thank you very much indeed for giving up much of your time to respond to questions, even though you are of a senior age and that your health is not very good, but you've been cooperating very well. The Chamber would like to say that we do not need to question you again on this, and you may be dismissed. The hearing today comes to an end, and the chamber will adjourn now, and the next session will be resumed by tomorrow at 9 a.m. in which TCW 488 will be heard. Court officer is now instructed to coordinate with the Wesu unit to ensure that Mr. Sao Sarun is well accommodated or sent to his residence, and that TCW 488 be called into the courtroom by tomorrow at 9 o'clock. Security personnel are now instructed to bring all the 3 accused persons to the detention facility and have them returned to the courtroom by 9 a.m. except Mr. Ingsari if he shows his position clearly that he waives his right to be present in the courtroom before 9 a.m. tomorrow. Then the chamber will rule upon the request and allow him to observe the proceedings from his holding cell through video link. The court is adjourned.